Without further ado, I'm going to hand you over to Kat, who's going to tell us a little bit more about herself.
Hi, good morning, everyone. As Nikki said, I'm Kat Moody. I'm an associate solicitor at Richard Reed Solicitors, specialise in employment law and also dispute resolution. So I'm well versed in issues of contention, and hopefully today we'll be able to give you some real pragmatic advice to avoid any contention in the future with employees. But today, really, the whole point of being involved with Nikki in these webinars for this session and others in the future is really because there's so many changes. I'm really passionate about making sure that we all understand those changes and we can prepare for them as best as possible. And then I'll pass you back over to Nikki, who I'm sure you all already know.
Thanks, Kat. So we try to make this as fun and as real as possible as we can. What you see is what you get with us. We're not professionals, we're not doing professional recording, although we will be recording this. So we will send out the recording of this to everybody that has attended and those who have registered and not been able to make it, as well as obviously our client base. So this will obviously, it's real, it's nothing fancy that you see online. So we're very real with real questions today. So a little bit for those who don't know much about myself, and maybe this is the first time you've met me. I'm the founder and CEO of Inspired HR and Inspired Mind Neurodiversity Services. I am a HR professional and have been for 33 years. I spent 24 years in corporates and I'm now in my ninth year in business. I am also a neurodiversity specialist, so I specialised. We are very niche in the UK as a service model, in that we specialise in neurodiversity for the workplace. So I am a screener, I'm an ADHD and neurodiversity coach, and I am also a specialist on legal advice and tribunal advice around neurodiversity as well. I'm also a professional coach. I do neurodiversity coaching, executive, HR professionals, etc. I'm also a civil and workplace qualified mediator. I'm a certified DISC profiler. I am a Durham University lecturer on neurodiversity, employment law, and entrepreneurship. And I'm ADHD, hence I have so many other things going on and so many other things that I've done, with a little sprinkling of autism in there as well, which is the perfectionist in me, and the workaholic and having to work the way that I do. I'm also currently writing a book and pending author. So when you get the post event email, you will also get a link to register your interest in my first of four books that is currently being written on neurodiversity in the workplace. The first one is for HR professionals. The second will be for line managers. The third will be for employment and legal professionals, and then the fourth one will be for employees. So I'm planning to release my first book on neurodiversity in the workplace later this year. So for those who didn't meet me and don't know me, there's a little bit about me, although not so little. So, what are we going to be covering today? We're going to be covering the ERA updates, or Employment Rights Act. For those who don't know what ERA, we get so used to saying it, we forget that not everyone knows the breakdown. So, we're going to be talking about the ERA updates. We're going to be talking about the national rate changes that come in April. We're going to be talking about SSP, paternity leave and parental leave, and then the whistleblower protection for sexual harassment. These are all key changes that are coming in April. I'll be going into quite a bit of detail when we talk about the SSP. I'm going to be talking about the practicalities of absence management and why it is important following the changes in April. We're going to be talking about the Fair Work Agency, and then we're going to be looking ahead at 2026 and 2027 and the changes that are coming up. What I'm going to do on this now is I'm going to close down the actual sharing of the slides, so it brings me and Kat back up on the screen, because when we do our webinars, we tend to do it as if we're kind of in a kind of chatting conversation. We don't do formal tons of slides like anything like that. It's just a real conversation with real information, and we don't do a lot of slides. So I'm going to stop the sharing so it brings me and Kat back into view. Um, Let me see. I think how you view it is however you choose to view it. And Again, I may play with the settings whilst Kat's talking. So Kat is going to be talking first about the Rights Act and giving you the latest updates in relation to that. Over to you, Kat.
Thanks, Nikki. So yeah, as Nikki said there, what we're hoping to cover today is quite a lot. And, a lot of those changes that the topics that we want to talk about are topics that are happening right now, changes that are happening next month. So there is quite a lot to little warning there. There is quite a lot to cover. But really, I suppose the best way to start is to give an overview for those that are in today's webinar who perhaps aren't familiar with why we have the Employment Rights Act, what's been happening, and what is currently on the timetable for change. So the first thing, just to remind everybody, is that the law for employment rights is currently governed by the Employment Rights Act 1996. It has not been changed for decades. There's been no, that whilst there has been change throughout, there's been no mass change for decades. And so the Employment Rights Act, which received royal assent last year and came into play in December 2025, is going to radicalise employment law as we all know it. It's the biggest overhaul of employment rights for a long time. The whole purpose of the Employment Rights Act is to act on what the government pledged, which was to make work pay, to strengthen employees' rights, to get the work-life balance more in line, and to give people greater protection. So that's the whole aim of the new changes. But as you can imagine, an Employment Law Act that's looking to completely change the landscape is quite detailed, and there are significant changes afoot. So don't worry, those changes aren't going to change overnight. They're not going to be introduced as one big law change because that would be impossible. But we are going to see predominantly change being introduced this year and next year. And actually, there will still be some changes that follow after 2027. But by January 2027, the landscape as we know it for employment law will look dramatically different. So yes, that's an introduction into the law where we're at. But the law only was introduced in December. The first changes were only actually introduced and implemented on the 18th of February. And those changes, which we don't propose to cover today because they focus on trade union repeals and reforms, it is significant because a lot of changes were introduced on the 18th of February around trade union reform. So if anybody's in this webinar today who is looking for more information about trade union reform, my suggestion would be to obviously contact myself and Nikki separately to today's webinar, but also we can recommend other resources where you may go to find further information about trade union reform. But today, because there is so much to focus on that's due to change in the very near future, we are focusing on April's changes and not trade union reform. So it is imperative that we all are prepared because the changes are substantial. And with that in mind, we've picked a handful, as Nikki mentioned at the outset there, we've picked a handful of changes that we're going to focus on today. And the big one, probably the one that's probably going to take us more time in today's session, is the statutory sick pay changes. But before we get onto that, it would be a great little segue, little introduction for you, Nikki, just to give us a little update on what the national minimum wage changes are going to be, because that really sets the scene for how much an employee is going to get paid from April.
Mm. Now, I did quite a bit of research on this around the national minimum rate because I don't know if anyone saw, I was on BBC Five Live. I tend to go on it every few months. And I did quite a bit of research where we were talking about the national living and national minimum rates and where they were all going up. And these rates were originally introduced in 2016, which was really interesting. So they've been going on for 10 years. And there's a lot of worry about the changes to the rates coming in April, it's massively affecting small businesses at the moment. I know within certainly the sectors within HR that I've been talking to, there's a lot of rumblings about the rises in national insurance, and we've seen some huge increases around national insurance and the rates. But we're actually starting to see some of these changes. I think I had a look at originally why this was all introduced, and what I researched was it was originally brought into place to combat poverty and establish a fair wage and reduce reliance on benefits. Some of the key things when they introduced it was protection against exploitation, ethical labour market and fair pay, and then to boost the what was happening within the sectors and the growth. Now, we've actually seen, I think, in some particular areas, retail, hospitality, this is actually having a huge impact at the moment, and we're actually seeing it massively affect recruitment. So in retail and wholesale, they have had the biggest loss of jobs, and hospitality. There's been 65,000 jobs lost since January last year, which is really worrying. And I know when I researched it, there was a lot of concern around the national minimum rates and where they were going up. So, but what we're also seeing is these are the biggest sectors with younger workers. So we're actually seeing a massive increase in youth unemployment. They've got the biggest impact on youth unemployment because of the way they've changed the national minimum rates now to where it's now 21 plus, whereas prior it had been 23 plus, and they've kind of raised the limits and altered them all. We've seen a massive increase. Now, I did some comparisons on the percentages around this, and in 2023, so over 3 years, we've seen the hourly pay rate and the annual pay rate for 21 plus raised by 25%. So a full-time equivalent would have been in 2023, 19,851. In 2026, it's now 24,784. That's a rise of just under £5,000 a year. That's significant for the SME market. And then for your 16 to 70-year-olds, there's actually been a 51% increase over the last 3 years in the rates. So they've gone from an average full-time equivalent of 10,296 to 15,600, a 51% rise. So we're seeing some changes. So what are the new rates? Well, the new rates in April for those who are aged 21 and over is going to move to 12.71, £12.71, which is a 4.1% rise. For those aged 18 to 20, it's going to rise to £10.85, which is an 8.5% rise. And for those aged 16 and 17, it's going to rise to £8 an hour plus apprentices, which is a 6% rise. What we've also got is SSP that is going to move to £123.25, and we've also got maternity pay, which is going to go to £194.39. So yeah, so we're seeing some significant changes. We know this is having an impact on the small businesses. All I can really say to the small businesses is do some planning around this, because it has changed significantly, and I'm not going to deny, and I was talking about this on the radio, it's really worrying me because we're seeing an unconscious bias now due to the age limits and the pay rates. We're seeing an unconscious bias within the younger generations where they are getting overlooked, whether that's consciously or unconsciously. It's not always obvious, but we are seeing a big increase in the younger generation out of work at the moment, because people are feeling, based on certainly ones I've spoken to, that they want to recruit someone a little bit earlier, but a little bit older because of the experience when they're paying the same rate. But we obviously know the issues that can lead to, Kat, in relation to discrimination. But yeah, they're the rises that are coming. A little bit worried with some of the SMEs. Very careful planning, but we are seeing a hold on vacancies, and a reduction in headcount happening in the workplace at the moment as well. What's your thoughts on what you think is going to happen from a legal point of view, Kat? Do you think you'll see a rise in claims of discrimination where some of this might be happening?
Yeah, I suppose that's the big worry, isn't it? Because SMEs are predominantly, focused on the finances, and every decision that is made you have to be considering what is that employee going to cost you, because it's not
Mhm.
necessarily just the initial onboarding cost. Of course, there's all the training, the everything that goes along with the cost of an employee. And so these rates that need to increase because cost of living is increasing. But I do feel like if you're going to be paying an experienced member of staff the same as a newly qualified member of staff because of age, because anyone over 21 is going to be getting the same rate, or at
Mhm.
least the same basic start rate, there is likely to be increased discrimination. Now, discrimination claims in recruitment can happen, so you can still be a claim can still be brought about against an employer for discriminating in the recruitment process. It doesn't have to be when the person becomes an employee, and that
Mhm.
is really important that everybody is aware of that, that any kind of discrimination right before they've even joined the firm is still something to be mindful of. And I do believe that if we're not careful about that, there is a real potential that discrimination claims, although yes, they have to be proven by the person who's applied for the job and but there's still a potential. And even a claim that is unsuccessful at a tribunal will still cost you, the employer, significant sums of money.
Mhm.
So it's about getting it right at the outset. But certainly that shows you the direction that we're headed, that there are additional costs to the SME market in particular, who are going to feel it the most. Equally, that takes us really nicely onto the statutory sick pay, because I think this again, the change is dramatic. Um, Perhaps for a larger organization that there's not as much concern over the change, but for
Mhm.
an SME employer, the change is significant, because what you're seeing now from the 6th of April is that 3-day waiting period for statutory sick pay will be removed. So
Mhm.
an employee will now be entitled to be paid statutory sick pay from day one. You don't have to wait until day 4 before they're started to be paid. And so, as I'm sure you're going to discuss, Nikki, there's that real concern that those employees who were reluctant to take sick because they were concerned they weren't going to be paid for that the first 3 days window, that they're now going to be able to obtain their payment from day one.
Mhm.
So that it becomes that 3-day wait is removed. The other thing is, as you mentioned, Nikki, the uh, the the lower flat rate is now £123.25, or 80% of their average
Mhm.
weekly earnings. That's what's now going to have to be paid. And I was reading, I've got it here, so apologies for looking down, but there's so many statistics that I can't remember them all. But what the government have said here is that they estimate that the changes to the statutory sick pay are going to cost around £500,000 annually, which is roughly £15 per employee per year extra, which when you break it down, perhaps there may be some people who don't think that that's a, a lot to worry about, but when you look at it as the economy,
Mhm.
it is significant, a big significant change. And then the other thing to do with statutory sick pay is to be mindful that the lower earnings limit is being removed. So previously, an employee had to earn £125 per week, which I think was the equivalent of around £6,000 a year to
Mhm.
qualify for statutory sick pay. That has been removed. So now, from the 6th of April, those employees who are earning less than that will still qualify to be paid either the 123.25 or 80% of their average weekly earnings. So there is a big shift there. Whether or not employees will actually think, okay, I'm going to take sick more because I'm going to get pay, or if it's only going to affect some employees, who knows? My personal view is that I don't think knowing that you'll be paid from day one instead of day 4 for the majority of people would change their approach to whether or not they're taking absence for sick leave. But of course, I'm looking at that from an employment law point of view rather than what you're seeing on the ground day in, day out from HR, looking at the trends of absence. So what were your views on that, Nikki? Because I think you were more concerned about that than I was.
Yeah, I've got huge concerns. Maybe I'm a little bit tarnished because I've worked in high volume industries throughout my career
Mhm.
where the absence can be particularly high, where people who are genuinely ill get the right support, but then we do have a lot of people that see it as additional holiday. The SME market had managed to avoid some of the high impact because where they didn't have the first 3 days paid, where people it made people think twice when it wasn't fully genuine or they could have come into
Mhm.
work. I think we're actually going to see a massive rise now. I think we're going to see massive issues. I think it's going to become massively unaffordable for businesses. And obviously I'm going to be covering off in a little bit more detail some of the recent training I did around the importance of managing absence because of the impact financially and people not coming in, because I think we are going to see a big shift in
Mhm.
non-genuine absence or people not thinking twice anymore and taking those first 3 days off. And there's a loss of incentive to come into work when somebody who maybe works 1 day a week can still get 80% or £123 pay for not coming
Mhm.
in. So they've lost. Imagine you've got someone who earns £100 and they work 1 day a week. They're going to get £80 to stay in bed, and that it's really worrying.
I
What
suppose from that point of view, how does an employer because it, in my experience, a lot of people who are taking sickness absence.
Oh, sorry, Kat. I've
That's all right. You just
I've
muted me.
certainly
That's
unmuted
fine.
you. Sorry.
Yeah, a lot of people who, in my experience, who take sickness leave tend to feel bad about doing that, which you shouldn't, because that
Mm.
creates a culture of nobody wanting to be off sick when they need rest. But do you think then that more people will take the leave just simply do you think there's going to be that uprise in people taking it off just simply because, you know, they're perhaps they've had a long weekend, don't want to come in on a Monday, so it's more, well, I'll take 80% of my wage. You think more people will be likely to do that?
I do, unfortunately. Like I say, maybe I'm a bit tarnished because I've worked in high volume
Hmm.
and we deal with a lot of complex, dispute
Yeah.
resolution. But yeah, I have. I mean, I can talk you. I'll talk you through. I mean, the key to this is managing your absence,
Hmm.
basically. So the reality is, and these figures that I'm going to give you now are in relation to total cost within a business, not just sick pay.
Hmm.
So an average person will lose 7.8 days a month. So if you take into consideration within a business, you've got people that don't take absence, some that do, but on average, the average is 7.8 days. Now, pre-pandemic, it was only 5.8. So there's now a significant average increase on absence. The average cost to a business per person due to absence impact is £700 a year per person. And that obviously that doesn't just impact the pay, it's morale, turnover, stress, financial pressure on other people to deliver the job. Now, some of the basic principles that you really should that some people forget is obviously the entitlement pay is going up from 118.75 to 123.25. A lot of people still forget that 0 hour contracts and casual workers are also entitled to SSP. And I think
Hmm.
where there is so much information available now, we are going to start seeing people on 0 hour contracts who don't work very often become aware and start putting fit notes in and claiming sick pay. And there is a value to their sick pay due to the way it's calculated. So, one of the most important things on this is basically your policy and your management around this. So, it's now more than ever having your triggers, doing return to works. And having a policy in place around attendance and contact is absolutely pivotal. It sets the standards and expectations for everyone. It enforces it consistently, and you must take action when you need to, in line with your policy. Now, do be very careful if you are taking disciplinary procedures due to attendance, because you cannot cross them over with other things. Attendance management warnings sit differently to conduct, so be aware for those that maybe are not so familiar with disciplinary processes. We're currently updating all of our policies and everything for our clients in relation to SSP. We've just done training around the importance of managing those trigger points, and we have, informal return to works on every absence, informal meetings on second occasion, formal meetings on third that could lead to warnings, again, case by case, because you have to take disabilities and other mitigating factors into consideration. But I personally think we are going to see a significant rise in the SME market on short-term absence. It's going to be high impact. So it's really important that businesses act quickly in relation to absence, especially with the upcoming changes to employment rights moving, which I know you're going to be touching on, because you will have to make decisions on whether people are right for your business much quicker, especially within the first 6 months. Now, one of the key things around absence that we do recommend with our clients, and we encourage this as part of induction, is health questionnaires are done at point of induction and regularly to understand what support your people may need in relation to health and well-being. Like I say, we recommend that it's done at induction. There is very rare occasions and exceptions where it can be done pre-employment if there's a specific need under the exemption for, i.e. health, for to be able to do a job. Regular reviews, and we have actually updated ours last year to include neurodiversity, which never used to sit in these things. Now, health questionnaires, it's important to understand they are not a way of catching out an employee. They are a way of understanding how is their health and well-being and what support may you be expected to give that person. Whether they come under the Equality Act or not, you have a duty of care to support your employees and have the right things in place to support them, whether that's reasonable adjustments under neurodiversity that's tailored to them and not Googled random adjustments online, which we are trying to ask employers not to do, or it could be well-being, chairs, desks, situations, working from home, flexible working, loads of different things. So it's about understanding and meeting the needs of your employees, and those health declarations being done annually, because you never know when the health changes. Now, one of the important things is making sure you make it very clear to your employees within your policy around what reporting absence and keeping in touch looks like. So when you do get a call, we normally highlight it should be a phone call unless by exception, directly to your line manager. And the whole point of that call is to ask about the nature of the illness or injury, the expected period of absence, contact details and arrangements during contact and what you expect around contact on that period, and also whether there is any outstanding work issues that need addressing. Now, obviously, fit notes, nothing's changing with the SSP. Fit notes are still self-certification for the first 7 days. A fit note is due from day 8. They can be issued from multiple sources: doctors, nurses, occupational therapists, online GPs, pharmacists and physios, so they're not just available from GPs now. They do say whether they're partially fit to work and what that might be, or whether they're unfit. Just to clarify, with a fit note, if you cannot meet the suggested changes to enable them to be fit for work, you don't have to do them if they don't work for your business. They are suggestions, they are not mandatory requirements. But obviously, if you want to support your employees being in, do what you can. One of the things I would say is be very careful with holding SSP when there is a delay between two fit notes, because sometimes it can be unreasonable. It could be just that the GP are taking the time, they're struggling to get an appointment, or they're struggling to get a fit note. Anything less than 4 weeks is short term. Anything 4 weeks or more continuous is long term. There is a misconception that you can only do welfare meetings when they go long term, and you can only do occupational health reports when they go long term. That's absolutely not the case. You can introduce a welfare meeting at any point. It's not just when people go long term, it could be underlying or intermittent or patterns
Mhm.
that are occurring. And occupational health, we've got a great provider that we partner with, and they're very unique in their model as well. They do a pre-meeting with the employer to understand what they're trying to understand and what, and what's going on and what that person's job is. And then you've got the post one. Now, something that people don't always realise, and you're obviously very aware of Daniel Barnett Cat, which is one of the
Mhm.
top employment barristers in the UK, that we're members of his organisation and work very closely with him and his members. Um, Occupational health report trumps a GP report. A GP report will never be fully impartial. They will only answer what they want and they can take months to get. We don't request GP reports unless we get occupational health to do it now. We always go through occupational health. It's quicker. We can quite often get them turned around in a week. They're much more impartial and much more honest with their opinion. And like I say, we've got a great one that we use for that. Equality Act, reasonable adjustments, some of the things to think about to make sure you're helping people get back into work. Phased returns, make sure it's case by case. Do not use other people as a benchmark. There is no time limits on phased returns. Temporary, permanent, hours, days, location, hybrid. Think about their roles and responsibilities. Think about their accessibility and their environment, and also think about any equipment as well. These are all things that should form part of that return to work
Mhm.
for these individuals. Now, some of the most common illnesses are minor illnesses, 94%. That's why I've got the worry cat that this removing the 3-day waiting is going to lead, because minor illnesses are 94% of absence. Musculoskeletal are 45% and mental health is 39% of when it comes to absence. Now, return to works are really important. Please don't use these as a tick box exercise. You
Mhm.
should be preparing and reviewing and gathering data before you do somebody's return to work. Do it as soon as they come back to work. It is their declaration. They are fit to work. Um, and it could jeopardize things if you don't do this. They should be informal, they should be private, they should be taken seriously and structured, they should be factual. You need to have a safe, quiet space to do them, and do document that conversation. We have great templates for our clients. Make sure you're using great templates. The kind of things that should be covered in a return to work include things like clarifying their pay, make sure they know what they're getting paid, company sick pay, SSP, things like that. Don't assume you think you know what the answers are. The whole point of that conversation is to ask them what's going on and what support that they're getting. Don't forget you've got a duty of care. You can consider phased returns, think about your reasonable adjustments. Sometimes medical suspension, if people are trying to return too early, be aware medical suspension is paid if you feel they're not ready to return. Um, they do not need a signing off fit note. That is one of the most biggest misconceptions. They do not need to get a sign off fit note from the doctor to return to work. They can choose to return to work. A good return to work will identify if they're coming back early and whether they're fit to return, to enable you to make an informed choice as to whether medical suspension is on occasions required. Look at underlying issues, understand the causes, look for patterns, monitor the triggers and talk to them about the history and what they've had in the last 6 months. Think about ongoing support, and don't forget they are effectively declaring themselves fit to work. If you are finding they are triggering 2 and 3 occasions within a rolling 6 months, which is what we tend to recommend, is
Mhm.
monitored. Informal meetings and formal meetings are instigated. You do have the right to request medical reports, occupational health at any point. It doesn't have to be long term. Make sure you are considering disabilities. You may need to increase triggers or remove the calculations and anything disability related from a calculation completely
Mhm.
before any decisions are made in formal process. Going to a formal meeting doesn't mean you have to put them on a warning. Normal formal process applies, invite, right of rep, right of appeal, all of the usual things still apply. It is a longer process, which is why, with the changes coming around employment rights, it is so important you start managing your absence. Dismissal should be last resort. Never dismiss somebody without having one occupational health as a minimum on record, and you may need multiple depending on the complexity. Now, when it comes to SSP, Kat's already covered off that it's payable from day one. They no longer need to have a minimum earning to be eligible for SSP. So anyone that previously wouldn't have got it in the first 3 days because they didn't earn enough will now receive it, including 0 hour and SSP. So even if you think your 0 hour person hasn't worked the last few months, so they've not got average earnings, they will, because when it calculates pay, it looks back at their last two pay dates, not the 0 ones. It looks at when they were last paid. Very complicated calculator on the government website. Very complicated calculation. I nearly threw something at my screen recently when I was using it, trying to work out the calculator because it kept asking questions when I thought it was done. So very complicated. Payroll is currently updating
Mhm.
itself. But we are going to start seeing changes and people will now be receiving a lot more. So be aware, and obviously be aware that the Fair Work Agency is coming, which Kat's going to cover, which if you're not paying your staff is a much quicker way of people dropping in and working out why you're not paying your staff. And they will look into everything from an enforcement point of view. Record keeping is essential. Obligations to keep accurate records, return to work, self-certificates, fit notes, what you've paid, what hours they're working, what shifts they're working, breakdowns of pay slips. You have a legal obligation to keep copies of all of this stuff, guys, so make sure you're documenting it. Um, and I think that kind of covers most of the things when it comes to
Mhm.
SSP. I'm sure we will get some questions when it comes to it. So most
Uh,
important thing, document and manage it.
mhm. I was going to say there, just to add on, in respect of the documenting things from a legal point of view, the majority of the time that employers come to me or employees looking for legal advice, it tends to hinge on whether or not accurate information has been recorded as to why a decision was made, as to why an employee was treated in a particular manner, what process they were following. If things aren't accurately recorded, or say for instance the policy hasn't been updated for a significant period of time, or like you've said, Nikki, things are treated more as a tick box exercise than any kind of bespoke real interaction with that employee, they make my job, if I'm acting for an employee, they make my job a lot more easier to prove that the employer failed to do something. And equally, if I'm acting for the employer and we're trying to defend a claim, it makes it almost impossible to prove the employer's intention, the motivation behind decisions that were made, because all of a sudden we're trying to remember why a decision was made.
Mhm.
And we're looking back quite often, a long period of time, the passage of time does make memory and information difficult to collate. So absolutely, if I could stress anything, with any interaction with your employer, is record keeping, with the employee, sorry, is record keeping, because if you are ever unfortunate to be in a position where your employee is threatening to take action against you, those documents could be the difference between being able to settle the matter amicably and avoid a tribunal, or the difference between tens of thousands of pounds in compensation and legal fees being paid out. So it always hinges on the documentation. And before we move on, Nikki, to the paternity leave, I thought it would be more of a curiosity really for myself, but anybody who's in the webinar, I mean, if it would be great if you could show of hands in terms of, are you as an employer worried about SSP? Do you have concerns for your own business about it? I mean, it would just be great if anyone could give us a thumbs up
Yeah.
if they were
Thumbs up
worried
or put
about it.
something in the chat, guys. It'll
Yeah,
be
in the
really
chat,
interesting. Thumbs up if you
just
think
to
it's
see.
worrying you.
Yeah, just really so we can gauge where more maybe information and support would be needed if people are really concerned about it. Of course, Nicola, you've got lots of resources. You did your
Mm.
webinar recently, or your training on absent management. And so I think there is this real, especially as you say there, concerns about 0 hours, bank workers, people who ordinarily may have not qualified for a
Mm.
payment. But yeah, it's just really more of a curiosity really from myself as to where employers are at. But yeah, should we move on to paternity leave then, Nikki, since we've got
Yeah,
a lot of other
we
topics to
can.
cover?
Yeah. Okay, so some of the other changes that are coming are paternity leave and parental leave. So on the 6th of April, it brings in day one paternity and parental leave rights. So paternity leave will become a day one right, allowing someone to give notice from the day that they start of employment that they wish to take paternity leave. However, what hasn't aligned with that, which was really interesting when that came through, was the actual pay element. So the pay element, you still need the 26 weeks service, but you can take paternity leave for or request to take it now from day one. So it was really interesting. Whether that'll follow, we'll see. But so again, just what does that mean? From day one, an employee can request to take paternity leave, but they still have to have 26 weeks notice to be entitled to the payment. For whatever reason, the government didn't align the two, which was really interesting. In addition to that, ordinary parental leave and unpaid parental leave will also become a day one right. So currently, someone must have worked for a year to take parental leave or unpaid parental leave. Obviously, that's now going to go to a day one right. Again, doesn't necessarily affect the pay. These are just day one rights and accesses to these things. And then also what is changing is eligible fathers and partners will be able to take up to 52 weeks of unpaid bereavement partners and paternity leave. If the mother or primary adopter dies, they must take this leave within 52 weeks of the child's birth, including surrogacy, adoption placement, or entry to Great Britain from overseas adopters. Again, quite complicated legislation. We tend to find a lot of this rarely comes up, to be honest, because not everyone can afford to take unpaid leave. But the rights of day ones are kicking in, but not necessarily the pay on these. There's very little you can do on these. They arise when they arise. Just seek support from your HR team around anything family leave related when it occurs, because it's one of those things, it's so complicated when it comes to pay and entitlement. Even we sometimes have to pick up the policy and go, I just need to remind myself of that, because it actually doesn't come up very often sometimes. So
would you suggest then that the only thing to do to prepare is just to review the your
make sure
family
your
leave
policies are up to
policies?
date. Yeah. So we're currently updated. So for example, some of the changes we're making is the SSP and absence policy updates. We're currently also doing the updates to the family leave one around these changes. We're also updating whistleblowing, which will be which you'll be touching on. We'll be touching on briefly shortly. And we're also introducing new stress, AI, and GDPR policies for our clients as well at the moment. So we've got all of those rolling out across April and May, where we're going to try and do them at the same time, so clients are not trying to juggle them. So there's some of the changes. So for those that don't have someone that just does that for them like we do, where we go, there you go, we implement it with their people. Make sure your team are updating these policies. So that's all you can do at the moment. But those ones don't often come up, to be fair, unless you're a larger organisation.
Yeah. What about I think a lot of people aren't really familiar with, we've all heard of paternity leave and maternity leave, but then when you get into the realms of parental leave and unpaid parental leave, my view is that not a lot of people are aware of what that is. Or so while you're updating the policies in respect of these kind of family leave, do you think then also, and I'm assuming that the answer is going to be yes, but that training around what, especially to managers and staff who are making these decisions, so they know what a person's entitled to, and also perhaps it would be useful for an employee to really understand that they actually have access to this unpaid parental leave should they need it and things like that. So as well as policy review, training, because the reason why I ask is from my point of view, when I'm looking at a case and an employer is accused of, wrong, treating the employee unfairly in some way or not doing everything that they should, quite often the failure is not making adequate records, but then also training being very minimal or not reviewed often, so that a person isn't aware of what they can do, or the employers, the manager or the supervisor isn't aware as to what's available to help an employee in a certain situation. So
Yeah,
do you
and
think training also hand in hand with reviewing the policies then?
yeah, and it is one thing that we're actually doing for our clients. So we introduced this year on the back of all of this that's come in, a monthly masterclass where we're doing top level on the subjects of family leave. That's our next one coming up. We've got our family leave masterclasses coming up in March. We've just done the absence one, and then we did the basics of HR back in January. So we've actually developed a 12-month program for all of our clients now. Technology is a wonderful thing. We actually record them, and it enables our clients to then use them for their line managers. There's so much businesses can be doing. They don't always need to bring in big expensive trainers. If they can and they've got the funds and they're a larger organization, they can do that. There are smaller companies, there's e-learning. So one of the things that we've got is we have the HR software that we do with our clients. And when we provide that with our retainers, we actually include the e-learning in the cost, because there's real micro snippets you can allocate to the staff as part of their induction and ongoing, and that's always updated. I mean, the e-learning on the software that we provide, it's recently gone from something like 25 modules to about 110, 120. And it covers everything from, minor things, lifting, to health and safety, GDPR, office practice, harassment, bullying. It covers everything. So e-learning is always a good one. I know in our software, I mean, our software starts at £22 a month. Costs nothing to build it at the moment because we're offering free build. So you've got options of e-learning within a software platform. If you've got the funds, you can bring someone in to do face-to-face, or you can do virtual and record it like we do. And then that can then be used for any of the team or the managers ongoing. So yes, you absolutely need to be updating people on
The
this as
training.
well.
Great. And what about, because you mentioned there as well, the whistleblowing. I
Yeah.
suppose, although that's a small change, it's worth mentioning now because I suppose the preparation for whistleblowing again is going to be the same, updating policies and making sure everyone understands what that is. So
Yeah.
what is the change on that?
So with whistleblowing, it's a very complex. Sometimes we see employees use that name randomly but it is about raising things in the public interest. And with everyone has heard of whistleblowing. Um, but basically, what's coming into play now under whistleblowing and what is now going to be part of whistleblowing is sexual harassment disclosures. Now, we saw in October 24 the changes around sexual harassment come into play. We did a lot of training with our clients. We recommend it's refreshed once a year or regularly, 12 to 18 months that you refresh with your staff. I know again you can do that through e-learning. The platform we use has an e-learning version. We have a version that we use, which is virtual and recorded for our clients when we do it as well. But basically, sexual harassment is becoming a qualified disclosure under whistleblowing law. Now, we are seeing a rise in some of these claims on the back of the historical things that's happening. And I think just the whole level of things like the kinds of things you need to be putting into practice, anonymous emailing. We offer a service. It only costs you if someone actually emails in, and it gives them the choice as to whether we can disclose who they are and look into it. Obviously, that's the business decision, but it enables, some of those disclosures. So confidential helplines, confidential emails, nipping these things in the bud before they get out of hand. So basically, this is protection around the detriment and unfair dismissal for whistleblowers making a sexual harassment disclosure in the business. So it's protecting those individuals where they've raised it, because we've seen what's happened historically around these things, especially in the entertainment industry. This will change on the 6th of April. Now, again, linking it back to the harassment stuff we've done before, make sure your bullying and harassment training is happening. Make sure you've got notices up saying that harassment of your employees is a non-negotiable and will not be accepted in any circumstance, especially if you've got public areas. You do have liability for anyone that does it in your business or your premises, including customers and clients. So, again, all of these different things you need to be careful of, not just what's happening. It's not just what's happening in your workplace. Clients, customers, contractors, you need to have the protections and the training in place. And the non-acceptance of any of this behaviour very, very clear in your workplace. We
Yeah.
think we're going to see some rises in this, all right, coming up.
I mean, from an employment law point of view, a, a lot, quite a high percentage of the inquiries that I get from employees are of a sexual harassment nature.
Hmm.
So out of all of the things that people can complain about, when they, I mean, it's probably a disproportionate number of people who come to see me are alleging sexual harassment. So,
Hmm.
and the as you've said there, the law around sexual harassment in the workplace was strengthened in October 24. This whistleblowing protection is just adding to that, given strengthening the protections that are already there, and rightly so, because of course, as an employer, there's an obligation to make sure the office, that the place of work is safe for
Yeah.
your employees. So it's all just building upon what's already there. But as you mentioned earlier, Nikki, the Fair Work Agency, um, which is also coming into play on the 7th of April. This is
Hmm.
now, they're going to have an organization going to be tasked with enforcing these things that should be done
Yeah.
correctly. And so the Fair Work Agency will have jurisdiction and power to take action against employers who are failing in their duty to keep employees safe, failing to pay statutory sick pay, failing to do the basics. And
Hmm.
so, as well as introducing these changes, the government have been very clear to say what will be the consequence if you don't adhere to these changes, of which there are many. But if you aren't prepared now and you aren't dealing with them in almost piecemeal fashion, each individual change, preparing for it, micromanaging those changes as best you can, there is real danger that the Fair Work Agency will pay you a visit, will step in.
Yeah.
Now, I suppose the only thing really at this stage to say about the Fair Work Agency is yes, it's been implemented on the 7th of April. And whilst the Secretary of State has been given power and jurisdiction to have a Fair Work Agency, the legislation doesn't yet go so far as to say exactly where that jurisdiction lies, what
Yeah.
they'll be able to do. And there needs to be a transition as well between the Fair Work Agency taking over from already existing agencies who have individual powers, such as the DWP,
Yeah.
HMRC, all of those individual bodies. Their powers will eventually transfer to the Fair Work Agency, who will be the overarching kind of governing body when it comes to employee rights. So I
Yeah.
suppose at this stage, yes, they are now being established, but how far their reach is yet to be seen. But it is worth us all being aware that there
Hmm.
are real consequences, and not just from the Fair Work Agency, but consequences that if you breach any of these regulations and new rules and reforms, and you are successfully taken to a tribunal by an employee, it
Hmm.
is very likely that employee will secure a higher percentage of compensation on the back of you, the employer, failing to take certain measures.
Hmm.
And so at this stage, it's not to scare anybody, but it is to make sure that there's a real importance placed on why we're saying each individual change may not seem significant, but
Hmm.
when you've got a lot of small changes all taking effect at the same time, there is a real possibility that something slips through the net, which means
Yeah.
there's a real possibility that the Fair Work Agency or the tribunal can obviously make decisions which would financially impact and also reputationally impact your business. So that's just to
Yeah.
be aware of the Fair Agency. That is something that I suppose that's the last change that we were going to talk about from
Yeah.
April point of view.
And
But
they will rock up to people's
Mhm.
workplaces like HMRC do. People do need to be aware that when it's given employees a single point of contact to complain about their holidays, their sick pay, their national minimum rates. And if they get complaints about some of these small businesses, they will rock up and audit everything that you do, similar to HMRC would have when it comes to tax and national insurance and VAT.
Yeah.
I mean, it's going to be a long process. It's only just been introduced. I am hoping, and I know we've talked about this in some of the sectors, and we've had a conversation about this. I am hoping that the Fair Work Agency will enable a quicker resolution to unlawful deduction claims, because the costs with ACAS and tribunals and how things escalate. I'm hoping things with the Fair Work Agency will start to get resolved much quicker and more
Mhm.
affordably for the small businesses, with genuine claims
Mhm.
as well, and get rid of the vexatious ones.
And my view on the Fair Work Agency as well is that there are many employees who do have legitimate claims against an employer, but due to financial restraints, do not take legal action because they can't afford to pay for a solicitor, or perhaps the stress of a long drawn out litigation process is too much. But now, knowing that they can go to one single organisation to report that employer for wrongdoing, some employees, when I speak to them, aren't always looking for financial gain. They want the employer to pay, they want the employer to be held accountable for something. And that's justification and justice in itself for that employee.
Mm,
So, from an employer's perspective, it's just being alive to that. The employee, even if they've got no intention of taking legal action against you, may just be able to kind of, you know, to take action from the sidelines by just
yeah,
reporting you, and then the FWA come in and they
yeah,
investigate you. The employee spent no money and not taking you to court, but they've still been able to get that little victory because you're now
yeah,
under investigation, or you've been fined, or you've been sanctioned in some way. So yeah, I think that's probably going to be used more by employees, because it's the idea of going to one organisation and reporting, rather than having to try and figure out, well, who do you report your employer to for this statutory sick pay issue, or that, or
yeah,
holiday deductions. So I think that's just something to be mindful of.
yeah.
And
So
those are all the changes from April,
April,
or at least the ones where we think that's where the
the key
main focus
ones, yeah.
should be. But there are other changes that we've discussed, Nikki, that
Mhm.
when we look ahead at even this year, when we look ahead, and both me and Nikki, we've got this long timetable that's many pages, with all of the full timetable of every single change that's been proposed. But I think the key ones when we're looking ahead later this year, I wanted to touch upon harassment. So we're looking at October, for harassment. This is where the law's changing. So as Nikki mentioned before, harassment from third parties, so customers, clients, things like that. What the law is doing is there's a small change in terms of the wording, but an actual huge implication from that change. Currently, the law says an employer must take reasonable steps to prevent sexual harassment or other types of harassment from third parties. That law is now changing to introduce the word all. So a small word, but with such big consequence. So now an employer must take all reasonable steps. What is all reasonable steps? What might be all reasonable steps to your organisation may be entirely inappropriate in another setting. So we're still waiting for code of practice and guidance on what the government actually mean by all reasonable steps. But if you're found to have failed to have taken all steps that you should have taken, of course, there are significant consequences if an employee takes action against you. So that's just to be mindful of. Looking ahead, that's October. Also in October, there was the issue with regards to tipping, which the legislation on tipping, which was introduced previously, that's
Mhm.
now being amended slightly to say it's all about the consultation, making sure you're consulting with your employees and workers in respect of creating your tipping policy. So do you also do that, Nikki, as well? Do you have a
Yeah, we
tipping
do.
policy for clients?
Yeah, so
Um,
we
because
have a
that'll have
tipping
to be
policy.
changed slightly.
Yeah, so
Yeah,
we'll be updating that nearer the time, where it will reflect that they'll need to review it every 3 years.
yes,
I don't think we've got much change doing it because I think we put in their regular review
hmm,
anyway. We're just going to put that
yeah,
definition in it now. But
hmm,
yeah, we obviously use that for things like our beauty salons, our hair salons, our retail, our hospitality clients where that applies.
yeah. And I think, I mean, because that it's been historically understood that tips were never really counted in the way that they are now. And I think there's still a misunderstanding about what you're supposed to do when when an employee receives a tip and how that's supposed to be managed financially and where it's supposed to be recorded and everything. So the policy is such a really crucial bit of information for you and your staff, so everybody is very clear about what the law says about tips. But yeah, so it's not a huge change, but they are strengthening that it should be reviewed every 3 years and that you have to consult with your employees about what goes in the policy. And I think the last thing from this year that I wanted to mention, and probably one of the ones that's causing me a little sleepless nights because I think it's going to potentially increase work, is the tribunal time limits.
Mhm.
They're changing in October, and it's a huge one for employees and employers
Yes.
because effectively what we're saying is it's currently on average most cases, an employee has 3 months less 1 day to bring a claim to a tribunal for things like unfair dismissal. And what the change is that that employee will be given 6 months now. So 6 months, that's 3 months longer to gather evidence, 3 months longer to save or secure finances in order to be able to pay a lawyer to assist them with the claim. That's 3 months longer for you, the employer, to have that uncertainty hanging over your head as to whether or not your employee is going to take action against you, your former employee is going to take action against you. So it's just, it again, it means that there's this uncertainty which lasts a lot longer. And I think as a result of that, will give both parties the opportunity longer to try to enter into amicable settlement discussions. Because when you consider paying the employee a particular sum of money and having that signed off in a settlement agreement, as opposed to waiting 6 months to see if they're going to sue you and then the costs of actually being sued,
Mm.
I think it does widen the scope for negotiation, and perhaps once things have settled down, the employees left, everybody's been able to reassess what happened and why. Maybe that'll, strengthen an appetite for negotiations between parties. Or
Mm.
if not, it's going to probably, in my view, create claims at the tribunal because 3 months currently doesn't often give a person enough time to even get the finances sorted that they need to pay for a solicitor. If
Yeah.
they're given 6 months, perhaps they would have found a new job during that period of time, been able to save some money or secure financing elsewhere to be able to afford. Because from my own views, the majority of people who come to me who do have claims against employers who choose not to sue the employer, the main reason for doing that is finances.
Yeah.
So most people say to me that if they could afford to pursue the claim, they would. So if they're
Yeah.
given more time to generate finances, perhaps we will see an increase.
Yeah. I
So
mean, there's
again, just want to be aware of, I would say at this stage, because it is October that's changing.
it is, I'm not going to deny it's worrying me. With the changes that we've got coming, the tribunal service is already broken and struggling to cope. We've obviously got day one rights, or 6 month that we still refer to it as day one rights, but it's the 6 months rights
Mhm.
coming at the end of the year. So they won't need the 2 year service from fair dismissal. It'll be 6 months, which obviously I know you're going to touch on. We've obviously had ACAS conciliation that's been extended to the 12 weeks. That's because they're so backlogged, they're just not coping.
Mhm.
We've obviously got the tribunal service now going from employees have got 6 months to bring a claim from October. Plus, we've then got the new rights coming in January. We're expecting a rise in claims. It has its pros and cons. It gives employers longer to prepare and save up and do what they need to do. But I think it's also given that real uncertainty for individual for them as well. But it's
Mhm.
also where there is a genuine case where that employee absolutely deserves and has the right to bring that claim because whatever's is not right, it is given them that space and time to do it as well. So there's pros and cons to both of it. It's worrying me on the back of everything else that's coming, um, on the impact that it's going to have, and also the impact it's going to have on an already broken service around tribunals.
Mhm. Yeah, and I think also because um, the the time period, 6 months, half a year to figure out if somebody who left your business a long time ago is still a threat, and not being able to mitigate that risk any more than just simply waiting, it does
Hmm.
put an employer in a very difficult position because you can't be proactive in that situation. All you can do is be reactive, which is an uncomfortable stance to adopt.
Yeah.
So that's why when we constantly say having things written down, having policies reviewed, doing correct training, making sure absolutely every record is recorded, reasons and justifications for decisions made, that's not because me and Nikki love paperwork. It's because that is what's going to save you from a potentially expensive claim if it gets that far. But also, if your employee understands that you've made records, you've ticked all the boxes that need to be ticked, you've been meticulous in the detail, they're less likely to feel that bringing a claim against you would be worth it because they're up against a fight and battle if they, know that you are on the ball with everything. It's the
Hmm.
employers that aren't doing the basics that are at risk and that face the most uncertainty during that period.
Hmm.
Um, but certainly, I mean, I, I appreciate there's a lot of change there, and that's just touching upon a few changes for this year.
Hmm.
But then that you've mentioned as well, Nikki, the changes that come in 2027. I think the
Hmm.
big thing to note is by 2027, we are going to be looking very different to how we look now as an employee, the employment landscape.
Yeah.
Because the change in 2027, um, it's worth mentioning there were a few, there's loads of changes, but there's
Mm.
two that worth mentioning now. Um, just on the back of what we've just said there about the tribunal limits, it's probably a right appropriate time to mention, like you've just alluded to there, Nikki, that the protection is changing as well for unfair dismissal. So currently, as I'm sure you're all aware, your employees have, they have to, there's this length of service, 2 years before they can bring claims for unfair dismissal,
Mm.
ordinarily, unless that unfair dismissal relates to discrimination of some kind. But ordinarily, 2 years service is needed. That's changing in January. So not only have your employees got longer to bring claims against you, now in January, they don't have to work for you for as long before they're able to do that. So there was a proposal that it would change to day one, so they would all get the rights on day one. That's been changed to say that those rights kick in on 6 months. So
Hmm.
now an employee does not need to work for you for 2 years from January next year. After
No.
6 months, they have the full rights that they would have if they had been there for longer than the 2 years,
Yeah.
as is currently the case. So that's important. And then on top of that, also the compensatory cap on what kind of awards an employment tribunal can make has
Hmm.
been removed.
Yeah.
So
And
that's gonna the
it's going
landscape
to
just
change the
in
landscape
respect of
completely.
tribunals completely changes. By January next year, the tribunal's going to be able to award unlimited compensation.
Yeah.
There's going to be longer for an employee to sue you, and they're going to be able to bring claims quicker.
Yeah.
So all of those combined, um, by January, a
Yeah.
huge change.
And things for people to think about that they may not realise is anyone that's starting in your employment now will gain automatic rights. They don't, so if you're thinking, well, this is not coming in until January, and it goes to 6 months in January, but it's currently 2 years, no, it's retrospective. So anyone who started now will get full employment rights on the 1st of January when this comes in,
Yes.
because they would have already completed 6 months service. So anyone that started now and even up to the 1st of July will get full rights on the 1st of January because they've already completed 6 months, because it's looked at
Mhm.
retrospectively. And obviously anyone that starts after the 1st of July, they will obviously kick into the 6 months instead of the 2 years as well. So if they've got 3 months to start October, November, December, they'll get full rights in March. So be aware it is retrospective. So anyone you're taking on now, you need to bear in mind they will get full employment rights in January. Now starting to update and talk to our clients, and we've got training coming up in relation to probation. So one of the things we're doing on the back of that is updating our employment contracts for our clients. And this links in nicely to the other bit that I'll talk about in a moment. We're currently updating our contracts for new employees, because obviously any current employees on contracts you would need to consult or gain their approval to change fundamental terms and conditions on some
Mhm.
things. But when it comes to probation timeframes, we normally recommend 6 months probation with a 6 months extension where needed, or up to a further 6 months. We're changing our contracts to reflect 10 weeks probation with the option to extend up to a further 10 weeks. Now, the reason we've done that is people forget to do probation meetings. And then you've got the week's statutory entitlement of a week that can tick people over into the 6 months. And once they've gone in the 6 months, you cannot exit somebody if they're not right for your business under the current short-term processes. You can only do that in the first 6 months and probation. We're waiting for whether there's any additional guidelines on probation, but at the moment we're recommending 10 weeks probation with up to an additional 10 weeks extension. That means then if you forget and you're not consistent in your probation process, it's giving you that 4 week timeline to fix it and sort it, but not forgetting that that statutory notice of a week can't, if people think, oh, it's all right, I'll do it the week before. No, your statutory notice will tick them over into full employment rights. So this is why we're making changes, and we're making sure our clients are aware of that. Other changes obviously come in 2027, and we're waiting for the updated code of practice in 27 on this, is the fire and rehire. So where at the
Mhm.
moment you can try and enforce a change to somebody's days, hours, and terminate their current contract and re-employ a new one, that will cease. And the only reason time you will be able to do that is if you can show your business is about to financially go into liquidation. So where at the moment it could be, especially in industries like cleaning services, I know we've got one of our clients on here where you might have a client that says, actually, I don't want morning cleaners now, I want an evening. Unless that business is about to crash and burn financially, you can't move their hours without their permission, and you can't terminate the current contract and put on a new one. So I know we've got some real risks on clients where they have demands of their clients as well. But yeah, it's going to be an absolute nightmare. We're looking at variation clauses in our, I see a little poo coming up on the screen from the client. Who knows that's going to affect him? But we will have a lot of it's going to affect everyone. They're obviously going back into consultation on it because there has been challenge and lobbying to the government that being the only exception to use fire and rehire is not fair on the smaller businesses, because they need to make quicker and swifter moves. And if employees won't agree, it's going to put pressure on them. So fire and rehire is the one we're looking very closely at the moment. It's going to prevent changes to days, hours, jobs, locations, any changes to T's and C's. It's going to prevent unless that business is at risk of financial insolvency. And that's the only reason. So we are lobbying and waiting for the consultation to see if they'll bring anything in. But as we've seen at the moment, there is very, very heavy unionised and influenced change incoming that's leaning
Mhm.
very towards employees at the moment. So we don't know what that's going to look like.
I mean, what I would add to that is just even though we're saying that these changes aren't until January 2027, and that feels, quite a long way away, actually, there's real things that we can do now to just implement change and to get ready. So already start planning and strategizing for what will that look like in the future? Do your policies need to be updated? Does training need to be arranged? Do you need to change how often that's going to be delivered?
Hmm.
What do your employees need now? Like you say, the things like to do with SSP and sickness management, that is something that needs to be looked at right now to prepare for the change next month. So there's a real urgency there. But let's not forget that January isn't too far away actually, and it's really important that where possible, employers are implementing changes or at least planning to implement changes well in advance of the law changing, because it
Hmm.
changes overnight. 6th of April, all those changes that we talked about come in. What was before is no longer present. It's what
Yeah.
happens on the 6th of April. So equally, January, after Christmas, everyone comes back from Christmas holidays usually. That's a huge change at the beginning of January next year. So
Yeah.
I would just really
Don't wait.
urge
Get
everyone
prepared.
to kind of, yeah, I would say that, of course, throughout this year, we're going to be doing an employment and HR trend series. So, this is just the first one of a number of webinars that we're going to deliver on all of these different topics. And
Hmm.
it really is just to encourage anybody who's unfamiliar with the changes, who just wants a little help in terms of how to prepare, to join to these free webinars, come along to the sessions, because the idea is just to give a little bit more information to everybody as the year goes on, so that we all can be prepared as we can be. And I suppose the final caveat to add is that this is currently the proposal that we're looking at now. What the government decide to do, or what other regulations or guidance or delays or changes to the timetable are made, are unfortunately outside of any of our control. But all we can do is look at what we're told the changes are going to be and plan for those changes unless something else is introduced, and then we'll
Yeah,
obviously give an update on those changes as well.
we will. So we've got 8 minutes left. We've covered quite a lot today. I know there's a few questions come in, and I know Jenny's been looking at them. So we're going to move over to Q&A now while we've got 8 minutes left. So let's see what we can cover off. So
I think the only one that I haven't answered so far was just the last one from Helen about will paying a notice period when not extending completing a 6 month probation period tip someone into over 6 months service.
My understanding is it's statutory notice that will tip it
Yeah.
over rather than contractual. But from an ethical and reality point of view, don't leave it last minute, guys. That's why we're doing 10 and 10 to give our clients breathing space for new probations. If somebody's not working out for your business, don't leave it last minute. If you need to make sure that you're sticking to your probation processes, working to them and doing those reviews and managing employees much quicker. Don't worry about the timescale unless you're about to tip over. If someone's not performing, you should be reviewing it from very, very early stages. That would be my kind of thoughts on that.
And also just to be mindful that there are going to be further guides, there's going to be further information in respect of kind of the probation period element of that, which may kind of shed more light onto what the act is actually trying to achieve and what government expect from employers in that situation. Because it may be that they're more clear about whether or not contractual notice will also have the same impact. I
Mhm.
think, unfortunately, as has been the case throughout all of the introduction of the Employment Rights Act, when it was the Employment Rights Bill, nothing was certain. You prepare for one thing, and then another regulation or another update would be released, and they had completely changed, or they had been so vague in their proposal that the interpretation of it was so misleading and misunderstood by a lot of people. So unfortunately, at this stage, I think we need further guidance, especially around the probation and the notice, in order to really fully prepare for it. But my advice, especially from an employment law point of view, is always to err on the side of caution. So if there's availability to give adequate notice before that 6 month period expires, and therefore the employment period comes to an end, including notice within the 6 month period, that's going to protect you insofar as you're able to be protected in that situation, rather than even giving an employee the possible argument that it tips over. That's going to be expensive just
Yeah,
for somebody to
it's
determine
not worth it. It can
what
tip
was the
over.
interpretation. Yeah.
Going to tip over so quick. I'm just having a look at the questions. Paul, I know you asked about policies. Our general guidance is that one occasion happens, second occasion is an informal meeting that's documented. So that's where you're having an informal meeting of that. If they have the third one in a roll in 6 months, it can go to formal, because you wouldn't really be putting something on file on the first occasion. On the second one, a separate informal meeting around what you expect, where they are, what's going on, anything you need to know about. Informal is good practice about making them aware of what could happen with a third one. A third one within a rolling 6 months is normally at the point you would have a formal process. Otherwise, you're instigating formal processes very quickly. You can't issue any warning without a formal process. So do be aware of that. So that's why we normally say a rolling three, monitored very closely, and you're setting expectations, and it's still case by case. Kind of as far attached. I can see you already answered the one about if we cannot support reasonable adjustments during a return to work, then yes, they still stay off sick. But again, it depends. If you've got a fit note and a doctor suggested they could return with some adjustments and you can't accommodate them, then they remain off sick. That the sick note would still apply. If, however, somebody is coming back to work and they have took the decision to return back to work early, you can't really force somebody to go back on the sick if they've chosen to come back and do the job that they normally do and they're declaring themselves fit. If you do, like Jenny says, it would be medical suspension, which is full pay. If they refuse to have an occupational health, again, it could be contractual. You force them to have them. When they still refuse, you could take action. Sometimes it might be just worry, or they think there's an agenda. So it all starts with a conversation. If they're still adamant they're not doing it, then you need to have a very honest conversation with them that any decision you take will only be based on the information you have. You cannot consider anything else. So it could lead to a decision that's not fully informed. And that's where we have to make sure employees are aware of that. Yes.
And just to add on to that, Nikki, if it is a contractual requirement that an employee consents to that procedure being applicable in that situation, it's really important that at the outset that contract is crystal clear, that those clauses in respect of the referral to occupational health or GP or whoever it might be, they have to be absolutely transparent. They can't be left to kind of interpretation or the employee being unsure or unclear as to what the expectation is when they're supposed to engage in the process, what's going to happen with that information as well after they have engaged. I think it's really important that the paperwork at the outset is very clear about expectation, because if not, then you get into an argument as to whether or not the clause in the contract is enforceable. And so just to be mindful when you're preparing employment contracts, this is now as good of a time as any to review your employment contracts at the same time as reviewing policies and procedures. Does your contracts of employment do everything that you need them to do? It's a really good opportunity now to look at things to ensure that they're doing everything that you thought they were, and if they're not, what is available to you to make changes.
For our clients, it is in the contracts and it is in the handbooks as well. That was something we put in place. I know we've had a query around company sick pay. This is a common one that arises. People, when you have company sick pay being paid, SSP should be paid alongside it. People often just pay company sick pay at full rate and then they pay SSP. SSP and company sick pay should be paid alongside each other. Otherwise, what you're doing is you're extending their period of pay, because SSP is 26 weeks. So SSP kicks in, company sick pay would pay the difference up to the full pay that you would normally pay, or whatever that is. So just for those on here, you don't pay company sick pay and then move them to SSP. SSP should be paid from day one with company sick pay running alongside it, because the whole point of company sick pay is to pay the difference between SSP and the normal pay that applies under company sick pay. That way, then they're not getting, say, they get, for example, 3 months company sick pay and then they go to SSP, you're effectively giving them 9 months' pay instead of 6. So please make sure they're running alongside each other. It's a common misconception when it comes to sick pay. And I think we've covered all the questions, unless anybody would like to come on and has further questions for us that's not in the chat. If not, I think that now concludes it then. So thank you for attending, everyone. I hope you found it useful. The recording will, I'm away for a few days now, so the recording may not come out until next week. But if you have any queries, I've put some QR codes onto this slide for you. There's a QR code if you want to get in touch with Kat at Richard Reed. There's a QR code if you would like to speak to us at any of our team or think of any other questions afterwards as well. And if you want to do the free HR compliance check, no obligation, just to see how your business is doing from some of the key HR things that we talk about, feel free to scan the HR compliance check QR code. Thank you, everyone. Hope you enjoyed it and found it useful. And we'll see you on our next one in a few months.
Thank you, everybody.